Welcome back to another discussion on cannabis, startup companies, and the law. Think somebody's copied your trademark? Here's how to tell. Trademark law is tricky enough without considering the extra complexity of its interplay with cannabis, a Schedule I drug under the Controlled Substance Act. For the purposes of this article, we will assume that a company has in fact managed to procure a trademark for a good service in this industry. One of the more intricate and indeed litigious aspects of cannabis trademark law arises when one party claims that another party is using a mark that infringes on the original mover, either by using the mark without permission or by using an excessively similar mark. Of course, the defendant will seek to prove that his or her mark is sufficiently distinct from the first mover's mark so that there is no infringement. Clearly, there is a certain amount of subjectivity involved in making this decision, and in order to better codify the factors that go into determining whether or not there is infringement, the court will consult the following test. The Polaroid factor test. As a guiding system, the courts will use what has now been termed the Polaroid factors, where they were famously employed in Polaroid Corp. Versus Polaroid elect, to decide if there has in fact been trademark infringement. Fundamentally, the goal of the test is to ultimately determine whether the alleged infringing trademark would create customer confusion. Indeed, avoiding customer confusion is the crux of trademark law, and is critically important in the protection of intellectual property. While each factor is important, not all of them necessarily need to be met for the court to find infringement. Here is the test. Number 1, the strength of the mark. Number 2, the degree of similarity between the two marks. Number 3, the proximity of the product services of the two marks. Number 4, the likelihood that the prior owner will bridge the gap, which we will discuss in a later podcast. Number 5, whether or not actual confusion has taken place. Number 6, the defendant's good faith in adopting its own mark. Number 7, the quality of the defendant's product. Finally, number 8, the sophistication of the buyers. Naturally, each one of these points deserves its own discussion and conversation, which we shall have with other attorneys at THC Legal Group in the future. Examining this list carefully, one readily begins to see just how useful this test really is. Each factor seems to skillfully get at the bigger question of whether or not this mark is the kind of thing that may confuse a potential buyer. The more similar the junior's mark is to the senior, the greater likelihood for consumer confusion and therefore trademark infringement. Conversely, if the marks are not deemed to be excessively similar, the less likelihood there is for consumer confusion, and therefore a lesser chance the courts will find trademark infringement. This test should be used holistically without too much emphasis on each individual factor. We look forward to seeing you all on our website at www.thclegalgroup.com.